And thank you, ACC, for inviting us, having us here, so to speak. So with me today is my partner, Walter Stella. And I think you probably know both of us from prior ACC events. In fact, we did last year, we were just talking about this. We did a program on bias last year, and wow, what a difference a year makes in what we're discussing. So what are we talking about today? We are going to talk about, as we were discussing this, we have the regular, the same old statutes, regulations that protect workers in the workplace. We have the EOC, we have the DFEH, etc. In the last 7 months, we've had a overlay of COVID-19 issues on top of our pre-existing framework. So we're going to talk about both of those today, not only what the law provides, but also what some of the overlay is in some of the areas that we're seeing in the last 7 months. So what are we going to talk about? Vulnerable workers. The CDC has issued guidelines on what is a vulnerable worker. And for employers, that leads to a number of different accommodation and other types of issues. Remote work is a whole separate accommodation. And then family responsibility discrimination. And I'll talk a little bit about this, that this was something that the EEOC came up with an idea in 2007. And you could almost say it's pretext plus or intersectional discrimination, where there are 2 different types of issues. There's the underlying, it might be the gender, etc. But the discrimination is based upon that plus the individual's family responsibilities. And then there's retaliation for taking protective leave. And as you know, in both on federal as well as state, and now even in some local areas within California, there are all different new and exciting regulations governing leave in the workplace. And then there's what we would say the new normal, which is just generally COVID-based 19 and the types of claims that we've been seeing. So I'm going to start, and I'm going to talk about protecting vulnerable workers. And as I said, the CDC has identified basically 3 types of individuals as what they are calling part of the vulnerable population. Employees that are 65 or individuals that are 65 or older, but obviously in a workplace situation would be employees. Employees with compromised immune systems, and employees with serious and chronic health conditions. So we've listed a few different sources of information, FAQs, that you might want to take a look at as you start either reopening, or I hate to say it, closing and then reopening again, or dealing with issues from individuals. The EOC has a FAQs on this topic. The California Department of Industrial Relations also has something, and so does the DFEH. Although the DFEH is a bit, they have not really updated, that the EEOC has been, to their credit, they have been updating on a regular basis. So, just a caveat, if you are looking at EEOC guidance, you need to look at the end of their FAQ when it was published. And you'll see that they're publishing and updating their FAQs as they go along. So if you looked at something in June, you might want to circle back and see whether or not it's been updated since then. So for the vulnerable workers, the vulnerable population, an employer can't bar an employee from the workplace or take any other adverse action because that person is in that vulnerable category. So we get questions, and we're already starting to see lawsuits where individuals have said, people are being called back to work, but I was not called back because, you can add age, you can, I have a pre-existing condition, etc. Whoop, I think I went back. There we are. Carrie, I think that this is not working, going back and forth.
Okay, how would you like to do it?
Hang on a minute. Now I've got it. Now,
Oh.
we had a little problem trying to get our, now see, it's still, sorry, everybody who's watching. There's a slight hitch here with the slides. You will get copies of the slides and I will just go along and hopefully the slides will slow down and we will, or we will eventually catch up to them. So as I was saying, that you cannot have, as an employer, you cannot have an absolute bar on bringing people back to work because they are in a vulnerable population. But there is some language, say, for example, the individual has a disability, that if that disability poses a direct threat to that employee's health, they cannot be eliminated, that can't be eliminated or reduced by any other accommodation you might make, then you have a bit of leeway. But that's a really, really high burden. It's a really high bar to watch. So you have to be very careful that when you're making these decisions, that they are not based on, I would say, stereotypic decisions based on what you think the person can or cannot do. So vulnerable workers, another area of vulnerable workers are, and it's sort of the same, it's a regarded as claim, where the individual, you say, I'm not going to bring them back because I know that in the past they have been dealing with cancer, or I know because of other medical conditions they've revealed to me as an employer that they are going to be more, it's more dangerous for them to come back. So you end up with regarded as claims. And then I think the big issue we're seeing a lot of is age and COVID-19. Even before COVID-19, ageism, because of the increased age of, I would say, the baby boomers moving through, making their way through the system, that we were already seeing an increase in age-related claims. But under COVID-19, there's been even a greater uptick. And I think that's because I read something that I think it was the CDC, is that the risk of severe illness goes up with age, that 80% of the reported deaths to date have been adults that are over the age of 65. So we're seeing more age-related claims. So what does the EEOC says? The EEOC is you can't postpone a start date, withdraw an offer, or if you're looking at even layoffs, not, lay off the older population sooner or refuse or bring back the older workers solely because you're concerned that it's going to place them at a higher risk of contracting COVID-19. However, if the employee says something to the employer, the EEOC, the DFEH, and all the other agencies are really suggesting that employers be very flexible, that even though you might not be required, if somebody is just over 65, there's no disability, there's nothing else that is attached to that other than age, that you might still want to be flexible and see whether or not there are any other accommodations, even though legally you may not be required. So, right, under the age, you don't have an accommodation requirement, but the CDC, most of the agencies are taking the position, and frankly, I think most employers are, of being a bit more flexible on allowing employees, because of age and because they're in that vulnerable population, to decide whether or not remote work, telecommuting, or another accommodation might make sense. So that's a good segue into remote work as an accommodation. And Walter.
Thanks, Michelle. Thanks everybody for joining. I hope everyone's having a good conference. When we first talked to Carrie about doing this presentation, I think it's fair to say that Michelle and I never thought that we'd be doing this virtually. This is certainly a very, I'll call it very interesting times. As a result of it though, as we are all virtual here, remote work is front and center, certainly for many of us that work in an office environment. And I looked up, SHRM did a study about a month or two back, pulling in information from various sources. And it was interesting to see sort of the good and the bad. The good is that productivity levels have been good. There was, I guess, lower productivity when the pandemic first started, but companies are indicating increased productivity. Employees feel that they're being more productive by working at home. Parents, and not just parents, but employees generally prefer the flexibility of working remotely. And 93% in a survey that was done by Global Workplace Analytics, 93% of employees would like to keep working remotely. Now, there has been some difficulty. There are some challenges. Folks working remotely, particularly if they have other demands, this comes up most often when you have childcare needs. The balancing is a little bit difficult, can be very, very difficult, especially when we're talking about remote school related challenges. As well as managers who you're missing out that opportunity, like in the law firm setting, of being able to walk down the hall and communicate with people live spontaneously. And that can hurt the kind of collaboration that many companies are looking for. And I learned a new word, this notion of presenteeism. I don't know if I'm pronouncing that correctly, but it's this notion that people feel that they need to be present all the time. There are less demarcation points. People aren't going home. They're ever present and therefore working longer hours remotely. So that's some of so we've had some good and we've had some bad. But what about the legal issues in the workplace? So Michele, I think you have control if you flip me over to the next slide. What about COVID-19, working remotely? What are the legal issues? And in a larger context, the biggest issue that is on the forefront has to do with remote work as a reasonable accommodation. Now, that remote work as a reasonable accommodation was always a possibility well before COVID-19. However, generally speaking, courts were very much looking to employers and in many ways were deferential to employers with respect to whether remote work was an essential function of the job, whether it was required that people actually physically be at the workplace. And job requirements, job descriptions that specifically laid out that employees needed to be physically at the workplace generally was accepted. And although it was always a possibility, especially on a temporary basis, to have remote work as a reasonable accommodation, it certainly wasn't necessarily something that was always an obligation that an employer had to provide to an employee. And the question that COVID-19 now presents, particularly since the argument oftentimes that employers had was that, look, persons just simply cannot do as efficiently or as effectively the job that they need to do for us by staying at home. That was usually the argument that we would hear. And again, courts were generally deferential to this. Now the question is, since folks have been working remotely in many instances for 7 months or even longer, and as we saw in some of the studies, the productivity levels are there, can those arguments still be made? Or have we shifted legally to a different dynamic here where there may be obligations on the part of the employer to essentially allow employees to work remotely? If we go to the next slide, I want to break it down a little bit more before we actually answer the question and kind of look at it from two perspectives. One is from the employee perspective. Can an employee refuse to come into work, and particularly during this time of the pandemic? Can an employee simply say, look, I'm not prepared, I do not want to come into the physical workplace because of the dangers that COVID-19 and the pandemic presents? Now, as a general rule, just a generalized fear of getting COVID or just a preference that someone has that they would rather not go into work is not going to be sufficient legally from a legal perspective to allow the employee to continue to work remotely or to simply refuse to come into work. So that as a general rule is the case. There needs to be some legal hook, if you will, that would allow the person to stay at home. Now, reasonable accommodation is one of them, as we briefly mentioned. Another would be potentially a leave of absence. And there are a number of different leaves of absences that might potentially apply. And we're going to talk about that a little later in the program. But if somebody has triggered the right to a protected leave, then of course that would allow them to stay home. OSHA provides guidance that if there is an imminent danger at the workplace, and again, in the setting of a pandemic, that would basically require either facts that suggest that the employer is not taking appropriate action to keep a safe work environment, or there's been a breakout at the workplace and a number of people have come down with COVID-19, et cetera. But it would require something more than just simply the general fear of getting COVID-19. And there's also the protected concerted activity. There may be employees that are engaging together in changing any kind of terms and conditions or workplace situations, and that might be protected under federal law. But without some legal protection, without some legal hook for staying home, as a general matter, the employee does not have the right to refuse to come into work, and an employer can require it. Now, what about on the flip side, which would be the next slide? What about employers' obligations? Can an employer require employees to stay home? Now, the short answer is yes when it comes to COVID-19. If someone has the symptoms, if somebody is tested positive for COVID-19, an employer can require them to stay home. The issue or the reason for that is that they pose a direct threat to the workplace. So they are a direct threat to others if they come into work by potentially passing on the infection. So that would be the basis for telling someone to stay home. Also, potentially, it is a form of reasonable accommodation. For example, if an employee says, I'll come in, but I need you to buy me a hazmat suit. That's the only way I would feel safe, or that's what my doctor says. You don't have to, as an employer, provide the best accommodation. It's the most reasonable accommodation. And under certain circumstances, the reasonable accommodation may be to require the person to continue working from home or staying home. So those are the possibilities. And we have a couple of sites there for you, web pages to get more information regarding that. But those are the general rules. So for an employee to stay home, there has to be a legal hook. For an employer to require an employee to stay home, it's either because they're posing a direct threat to the workplace or that there is some legal obligation that it's trying to meet, and in part doing that by having people stay home, maybe in the form of a reasonable accommodation. Next slide, Michele. What about continued teleworking? So with that backdrop, what happens given that we have a number of individuals who are already working from home? Will it be an obligation for an employer to allow an employee to continue teleworking? And at what point can the employer require the employee to come to work? Generally speaking, if it is the employer's preference to have people come into work, then you can require it. One question that had come up is, what if an employee refuses to take the test? Because part of what many employers are doing now, based on CDC guidance, is in order to ensure a safe work environment, folks are taking health screening tests or they're taking COVID-19 tests. Well, what if an employee refuses to do that? Doing that in part so that they can stay home. Would that be a potential workaround? Generally, the EEOC guidance is that if somebody's refusing to do that, again, because of the direct threat nature, an employer can refuse to have or allow the person to come into the workplace as a result of that. And accommodating that really depends. It depends on the circumstances. Why is the person refusing to take the test? If there is a religious basis for it, if there's another medical reason for it, again, there needs to be some legal requirement on the part of the employer, some legal hook in order for the employer to necessarily have to accommodate it. So it does matter to ask the question, why? Why is the employee refusing? If it's just simply a preference on the part of the employee, they prefer not to be tested, that could be something that ultimately leads to discipline or the employers just simply refusing, because just because they can't come to the physical workplace doesn't mean without any kind of a disability or some legal hook, force the employer to say, okay, then you must work remotely. The other option, of course, is to take disciplinary action and say, then in that case, you're not working. You're not working at all. You're refusing to do the work as we're requesting it. And that is always a possibility. Next slide, Michele.
But again, one thing that, yes, go ahead.
Did you have anything to say, Michele, that you wanted to add, or no?
No, okay.
Medical certification, of course, is something that it has been required of employees, or it can be required of employees on the part of the employer when they're going through the reasonable accommodation assessment that we often refer to as the interactive engagement that the employee and the employer have to engage in order to make a determination as to what the reasonable accommodation will be. Now, those medical certification requirements are still there. The Department of Fair Employment and Housing guidance, however, is essentially recommending that employers be flexible here. Now, I think we're going through waves in the pandemic. I think this guidance came out at the start. There was certainly concern then that our medical system would be overloaded. It would be difficult for employees to get medical documentation, and the guidance both at the federal level, the EEOC level, and at the Department of Fair Employment Housing level was employers be flexible and potentially waive the requirement as needed in order to still allow the reasonable accommodation request, but at some later point get the medical documentation that's needed. My understanding currently is in California, it's not as difficult, at least at this time. We're not seeing the surge that I think other parts of the country are experiencing right now. But again, we're being asked as employers to be more flexible, if you will. And I'll talk about that flexibility and what that might mean when we talk about retaliation in a little bit. So next slide. What is the final EEOC guidance that we've received as it relates to teleworking, or at least the most recent? And this was updated just last month. As Michele mentioned, we're consistently getting updates as this is a very fluid situation. With respect to COVID-19 inquiries, there is going to be a distinction, or the EEOC has drawn this distinction between those employees who are teleworking and those employees who are coming to the physical workplace. Because of the direct threat nature of the pandemic, employers are allowed to ask employees whether they have COVID-19, whether they're experiencing symptoms, can require them to take tests to determine whether they have COVID-19. But that is only for those employees who are coming to the physical workplace, who are being asked to come into the office. If you are teleworking, according to the EEOC, those are not appropriate questions. There is no direct threat if the employee is not coming to a physical location. So those questions, asking someone to fill out a health questionnaire just to start work while they're teleworking, would be inappropriate. Confidentiality. The EEOC also came out and made it clear that during this time of teleworking, information that's medical in nature must be kept confidential. That means that for anyone who is an employee whose tasked or whose duties include maintaining that confidential information must do so. If the information is being kept digitally, then we have to take steps as employers to ensure that that information is not accessible to others in the workplace that shouldn't have access. In other words, you can't just keep it in your email. You have to take steps to make sure that that information is being kept confidential. And for those employees who are teleworking for reasons related to COVID-19, either because they're experiencing symptoms or that they tested positive, we are not to disclose that. We still have to maintain the confidentiality of any medical information that we've been given during this process. And finally, on the reasonable accommodation, and this answers the question that we started out with. So folks who are teleworking, does it necessarily mean then that if they ask for a reasonable accommodation in the form of remote work, that we are required as employers to provide that as a reasonable accommodation? And the answer is not necessarily. Not necessarily. It will depend, it's very fact determination. Simply because someone can work remotely and simply because that does potentially accommodate the disability doesn't mean that that's the only accommodation that could be provided. And that's going to be the test. It doesn't mean that it has to be the best accommodation. It means that it could be one of the accommodations, but it's not necessarily the case that just because folks are teleworking and just because it's something that has worked now during this time period, that it would be something that has to continue. The other thing, the final point, employers are allowed to ask now whether whether folks upon return to work will be seeking reasonable accommodations and what form. So you can engage in the interactive process now. What is clear though, the EEC was very clear about this. It will not preclude individuals from asking or seeking reasonable accommodation later. So if they ask for and engage in the interactive process today about the potential or what they may need when they head back to work, whenever that is, doesn't mean that down the road they can't ask for an additional or different reasonable accommodation. Or if they're silent now and haven't asked for it, it doesn't mean that they're precluded from doing it later. And then I think with that, Michele, I'm going back to you.
Okay, so Walter, one of the things that, what we talked about at the beginning, there's this overlay of COVID-19 on what are laws and regulations that we've lived with for, a number of years. So when you're dealing with an accommodation, even though there is that overlay of COVID-19, it is still the same framework that you would normally engage in interactive process, seeing what is reasonable, seeing if there's something that you could provide that meets the same objective. So it's almost like a 2+. And then the other thing I just want to point out, we're doing an overview, but in a lot of these situations, there are local ordinances and the opening up of various counties that also come into play, particularly with health screening and contact tracing, et cetera. So you have to be mindful of the federal, the state, as well as the local laws. So family responsibility discrimination. This is something that a type of discrimination that the EEOC recognized in the beginning, like around 2005. There were a number of cases, and they came out with guidance in 2007. And I think with a lot of the issues we're seeing today because of the remote work, closed businesses, shelter in place, schools that are all remote, issues with elderly parents and assisted living and nursing care. This is just an area that I think that it's worthwhile revisiting. So I was just looking at some of the statistics, and the Bureau of Labor Statistics, they said that women accounted for 55% of the 20.5 million jobs that were lost in April. So why is that? That a lot of that is because the areas that were really impacted, service industry, hospitality, et cetera, tended to be more women-dominated workforces. And there's a very, very recent case, and I apologize, I don't have the site here, but you can look at it. There's a case. There's a recent report by McKinsey as well as the Lean In, I think it's the foundation, that found that 1 in 4 women were considering downshifting their careers or leaving the workforce completely due to COVID-19. And when I read that and drilled down a little bit into the numbers, I was, I guess, surprised, but not that surprised that although women were considering this to a greater percentage, I was pretty surprised by the percentage of men who also reported these issues, which leads us to family responsibility discrimination. And what is it? In family responsibility discrimination, according to the EEOC, is a form of discrimination against men or women. It's gender neutral because of their caregiving roles for family members. So if you fast forward that into COVID-19, you have young children who are at home that have to be dealt with, that don't have childcare, that need to be supervised or act as teachers at home. You also have elderly parents, And it's also, there's been a significant impact on individuals that have learning needs or other disabilities that have been extremely impacted by school closures and COVID-19. So even though traditionally the way this has been looked at is having a much greater impact on working women, today, even though it still has a greater impact on working women, we can't discount the impact it is having on all individuals. So I put the EEOC guidance here if you want to take a look at it. It's May of 2007. I kind of called this, caregiving plus. It's, say, for example, you have two women applying for a job that requires travel, and one of the women has children, young children at home, and the decision is made that we are not going to hire the woman with children at home because she's going to be less able to travel. So in terms of gender, you have two same gender, but that plus factor is that family responsibility. And there's a number of different ways it plays into these types of decisions. And if anybody is familiar with a new area of the law that has gotten a lot more press or interest, called intersectional discrimination, or pretext plus, which is, for example, it's not just being a woman but an older woman, or it's not just being a man but an older man who doesn't get the position that requires being in front of a camera, public facing. So there are a lot of different ways where this that we're seeing family responsibility as something that's 2007, but even more relevant now in light of COVID and the impact it has had on those responsibilities. And the general, you read the 2007, we call it caregiver bias, which is stereotyping that individuals are less committed because either they have elderly parents they're taking care of, or they have young children, or because of those issues, they're not going to be as available. And you see this, we're starting to see some COVID-19 individual plaintiff cases where the individual is saying that I wasn't getting the work assignments at home, or I wasn't being considered for, projects because everybody knew I was also juggling having children at home. And sometimes they actually came in while I'm on a Zoom call and unfortunately showed up on the Zoom call. And so we're starting to see those types of claims. And this is, the distance or recency bias, which is what Walt just said, which is choosing to stay home rather than go into the office and engage in FaceTime. That's the before times definition, but I'm not sure that it is exactly an issue here. Although there are a number, and this is the intersection of all the leave laws as well as the other forms of discrimination, when businesses reopen and somebody, a female or a male, cannot come back to work because of these family responsibilities. And then the confirmation bias, this is another, as I say, that the before COVID ideas of caregiver bias. So, and there's a lot of issues, and this is something that we're seeing in the EEOC from 2007. What about the bias when people are working from home? Now, even under COVID-19, it's not giving the opportunities, not maybe having, opening the office for a few days, or being, starting to bring people back and not calling back the person that has the caregiving responsibilities. There are already some cases that we're seeing about comments that are made on Zoom calls about, a male or a female that have their kids that show up on their Zoom calls or are obviously distracted. And that's, not being invited to those types of calls because you have this distraction of kids. So there's a number of this is something to take a look at, is the employer best practices for dealing with workers with caregiving responsibility. There's no update on the EEOC yet about the intersection between family responsibility discrimination claims and COVID-19, but you should just be aware that this is a protection that the EEOC recognizes. So I just think it's an interesting topic to revisit in light of COVID-19. So we're going to move along because I know everybody's going to race out to that bar outside and get that drink so we can mingle. So I'm going to switch it over to Walter for avoiding retaliation claims.
Virtually mingle.
Yeah.
So based on everything that Michele and I have been talking about, one of the things that really sticks out in this era now of virtual work is that there are going to be plenty of conversations around leaves, accommodation, medical conditions, et cetera. And all of that is really ripe for retaliation claims. So if we back up a second and talk about what are we talking about when we talk about retaliation? Retaliation is fundamentally three elements. It's the concept of a protected activity, someone engaging in protected activity, that there is some kind of adverse action, and then there's a causal link between the protected activity and the adverse action. When we talk about protected activity, what are we talking about? Well, it's all the things we've been discussing, right? It's talking about taking protected leave, requesting a reasonable accommodation. Any and all of that is engaging in protected activity. You don't have to be right about it, and meaning someone can request a reasonable accommodation and perhaps they're not entitled to it, maybe because they're not disabled, et cetera. But the mere fact that you're engaging in that kind of a discussion places the employee in a position of having engaged in protected activity, and therefore is protected from being retaliated against, at least for that reason. As a practical matter, it makes it a little more difficult for employers because of that protected status when you're having these discussions. And the other thing to keep in mind is that there's no magic word test here. So someone could engage in protected activity by not having necessarily used the phrase of reasonable accommodation. They could be coming to a manager and talking about being under some additional stress during this time, possibly thinking about taking some time off. There is no magic word test. If it's enough to apprise an employer that the person is asking for some kind of protected leave, then they've engaged in that kind of protected activity. So next slide, if we consider from the perspective of both the employee and the employer, there are a number of different leave options. We've gone through them real quick just now as we went through.
Well, I'm sorry, the slide keeps
that's
every
okay.
once in a while. So you'll just have to just say, this is what the slide would say had I, but yeah, go ahead. Sorry, it just kind of goes along very quickly. Yeah,
and I was just going to touch on them because this presentation is not about the types of leaves, but it is important to note, as Michele noted really from the start, that prior to COVID-19 and the pandemic, there were a number of different leave related protections. Those protections have only strengthened now because of COVID. Some are specifically related to COVID. There's specific sick leave if someone has COVID, or if you need to care for someone who has COVID. There's also extended family medical leave. There's also in California, and we talked about this in our webinars, and we're going to cover it again, Governor Newsom signed some new laws that we need to be aware of. The federal protection for COVID-related leave, I'll call it, it really applies to those employers that are 500 or less employees now. Over 500, California has a protection, basically extends the protections under the FFCRA for larger companies, and that's going to go through the rest of the year. Probably the biggest and most important change is going to be the California Family Rights Act, where that ran in tangent with the FMLA, requiring employers with 50 or more employees to have that protection, and that would be when you have a serious health condition and you need to care for yourself, or you have a loved one who does, a family member. That is now in California, as of the start of the new year, going to be dropped to 5 or more employees. So many more companies are going to be covered by that. Also, it's expanded because family members under the new act, when it goes into effect next year, will include grandparents and grandchildren and siblings, which is not covered under the FMLA, along with domestic partner, which is covered under the state version, but not the federal FMLA. That becomes important because for the 50 employees plus, you may have employees who are taking time off under state law, but not triggering the federal law requirement. So someone could take perhaps 12 weeks to care for a grandparent under state law, CFRA. They're not exhausting FMLA, and then could take 12 weeks for baby bonding or 12 weeks to care for a spouse, for example, or a child, because that's covered under federal law and that's not being triggered. So all of these leaves are there. Having discussions about those leaves and those protections trigger the protected activity. And so retaliation, again, very simple concept. You engage in protected activity, there's an adverse action. Is there a causal link? And oftentimes you're looking at timing. This really could be an area that could be ripe for litigation. And employers need to just be mindful, and managers really need to be mindful when they're having these discussions. And remember that in the retaliation arena, an adverse action could take just about any form. So it doesn't have to necessarily be a termination. The fact that you're denying the leave itself could be the adverse action. So we just have to be mindful that in this era that we're currently in, given the discussions that we're going to be having with employees, it is really ripe ground for potential retaliation claims. It's a real potential source of risk here.
Yeah.
The new normal. I'll hand it
Okay.
back to Michele.
All right, hopefully we go one at a time here. Okay, so what are we seeing? Discrimination claims. We've talked about this, but these are the 4 categories that where if you start tracing or tracking the number of COVID claims since March, April to today, there's been a steady increase. It's not a huge spike, but there's been a steady increase in claims. And for the individual claims, other than the leave issues, we are seeing age discrimination, disability discrimination, gender discrimination, and national origin discrimination. And for the most part, we're talking about vulnerable employees, and it could be disability, it could be leave, could be accommodation, age discrimination, gender, which, there's a lot of issues with family responsibility right now, and then national origin. And we'll get to national origin in a second. An interesting thing, which is, I'm not sure this is COVID-19 related that much, but people who like to harass and make, stupid comments at work, the fact that they're not at the water cooler is not stopping people, so we're seeing a lot more, emails or Zoom calls where, there are things that just are not said. And sometimes even like in the chat rooms that are not, should not be said. So there is, we're seeing a little bit of online harassment by employees who are teleworking. And then negative comments, obviously that harassment, that little, uts to somebody saying, well, they really shouldn't be on the call because, their kids are at home and, he's going to be too distracted, those types of issues. And those are all, there's the statutory gender claim. And then you have on top of that, it's enhanced because of the COVID-19 situation. So just as in real life, in telelife, managers just need to be aware of this and to be careful that employees are not making these types of comments. And then national origin discrimination. There was in March, April, May, and continuing through today, there has been a surge in bias claims against Asians, which I think we can kind of put together why that might be. So there is and I won't go I won't give you the acronym, but this is an organization, obviously, that is, it's Asian American Policy and Planning Council, Chinese for American Action and California, and I'm sorry, in San Francisco State University's Asian American Studies Department. They've been doing this tracking. And through August, the verbal assaults, shunning, physical assaults, all of them have been a spike. And it's really something we haven't seen. There's always been national origin discrimination, national origin obviously against Asian Americans, but not like the spike since March. So that is one area. And the EOC is recognized this. They have one FAQ that basically reiterate, national origin, that managers, employers need to be aware of this potential for national origin based on Asian American in the workplace in the wake of COVID-19 and some of the comments. And we do have, the DFEH has issued some FAQs, but I said the DFEH has not been updating as frequently as the EOC. So then we have, Walter, why don't you take a look at, preference for recovered victims?
Yeah, this is, so as we're looking ahead, and then a little bit of this is looking at a crystal ball, there is this concept of reverse immunity discrimination. In other words, really a preference potentially for those employees who have immunity to COVID-19. And it sounds a little sci-fi, a little far-stretched, but you certainly could see scenarios, particularly maybe even in certain industries like the health industry, where you have health workers who might be on the front line, and those individuals who have immunity to COVID-19. There may be obvious advantages. Also, for purposes of those companies that may have essential functions and need certain employees to come into work who can't work remotely, those individuals who have immunity to COVID-19 obviously may end up getting preference for those positions and certain roles. What does that mean for society? Are we looking at potentially another form of discrimination if we end up going down that path? Right now, currently, the EEOC guidance, and it keys off of the CDC guidance, the EEOC guidance is that employers are not entitled to request that employees take antibody testing. And part of that is because the CDC guidance right now is that antibody testing is not entirely accurate given the testing that's out there. At least that's the CDC guidance view on it. And even if it were, there's not enough to show that someone with antibodies, which really reflects that someone has had COVID-19, at least right now, the research isn't there to suggest that they won't get COVID-19 again. So now, if that changes, will that change the EEOC guidance? We don't know. But as it currently stands, there's certainly the possibility of this concept of reverse immunity discrimination, which really is preferring those employees, if you will, for certain roles at least, because we know that they may not, they're not contagious, they won't get COVID-19, to put them in certain roles. Will we begin to see discrimination claims arising from that? We don't know, but that's certainly something that might be on the horizon. Now, mental and emotional disabilities.
And Walter, before you go on, we started a little bit late, so we're going to finish in about 2 minutes, and I know we've gotten a few questions that we'll get to.
Yeah, that's right. There are some questions, but and certainly take other questions as they come in. But mental and emotional disabilities, it's always been a challenge for employers. How do we accommodate non-physical disabilities in this day and age? With COVID-19, there are questions as to what really will constitute a disability. You need a mental impairment, and that mental impairment has to actually be something that is recognized in the medical community. Again, as I mentioned before, the EOC general guidance on this is that a general fear of getting COVID-19 is not seen as a disability, at least not a disability that needs to be accommodated. So does that mean that potentially there are pre-existing conditions that do need to be accommodated, that are exacerbated at this time, anxiety, for example? That is likely, and that is something that would need to be accommodated. I keep talking about a generalized fear. There are those individuals that may have developed a disability or a mental condition as a result of this.
Mhm.
And that would have to be something that would be accommodated. Again, medical certification is something that we as employers could rely upon. It's going to depend on the circumstances whether we have to be a little bit more flexible. And then certainly with mental health issues, regarded as claims has always been something that is a very real possibility. And I sometimes refer to these claims as no good deed goes unpunished. Whenever an employer tries to go out of its way to assist someone because they're having challenges, or at least perceived challenges from the point of view of the employer, you always have the potential for a regarded as type claim. In other words, the person may not necessarily have a cognizable disability that requires accommodation. But if you regard that person as having one, that may be enough to trigger protection, at least with respect to discrimination. Generally, the law is you don't have to accommodate a regarded as disability because there is no disability. But nevertheless, if they're regarded as having had a disability, then they're protected from discrimination, retaliation, et cetera. And we have some guidance there that you could look at on this slide with respect to regarded as claims. And then this concept of associational discrimination, and I always found this to be very interesting.
Mm-hmm.
The guidance with respect to associational discrimination is that if someone is associated with a person who has a disability, that association is protected. So in other words, you can't discriminate against a parent, for example, who has a child who is disabled. On the other hand, the mere fact that the child is disabled doesn't mean that you have to accommodate the employee. So it certainly is something that creates some tension at times, because if someone is requesting what essentially amounts to a reasonable accommodation because of a loved one's or someone who they're associated with disability, and the employer is resisting or saying no, is that discrimination? Is that retaliation? And that usually is what leads to those kinds of claims. And you'll see in the next slide that the guidance that we have is fairly clear on point. The ADA does not require accommodation of someone who's not the employee who has a disability. But at the same time, you're being asked to be flexible. And from the management lawyer standpoint, whenever we talk about flexibility, which is always certainly something we advocate, we're also talking about the potential for inconsistency. And at the heart of many discrimination cases, it's inconsistency that leads to the risk or the exposure for employers. So we have to be mindful that there are these protections. So just because someone comes to you and says, look, I want to take some time off, or I need to work remotely to care for my disabled parent or whoever it is, yes, the short answer, the legal answer is you don't have to accommodate that. The longer answer is, are we doing this under circumstances that could give rise to a question as to whether we're discriminating against or retaliating against someone because of their association with the person who's disabled. So some best practices, as always, training managers so that they understand what the issues are currently, what to ask, what not to ask, when to say no, getting guidance. Remember that the medical inquiries with respect to the pandemic and because of the direct threat it poses in the workplace has opened the door to medical inquiries that we wouldn't otherwise have the ability to ask, but they have to be tailored. They have to be tailored toward the COVID-19. Remember that when we want to do a good deed, we want to encourage people to stay home, but we're focused on certain individuals, especially if they're in that vulnerable class that Michele mentioned, or if we're regarding people as being disabled, that could lead to problems. So be careful there, because that's a risky situation. And then accommodations. I mean, that's the central issue here that we're talking about. And remote work in particular, the guidance we currently have, in many ways, things haven't changed. It's a case-by-case assessment. But it is true that given that people are working from home more, and assuming that it's been successful, that certainly will be an argument that you will hear if you decide to reject a request to work remotely on the basis that that person has to, it's just a requirement of the job to come into the physical workplace to work. It certainly will be something that we will hear as part of any litigation. With that, we'd like to thank you. We'll take some questions.
Wait, we've got one question, which is a nice segue into what you were just talking about, because it's specific, but I think it's general enough that everybody is going to recognize this. And the issue is our industry has privacy requirements, HIPAA, GLBA, that doesn't allow third party, i.e. children, to be in the same room for any discussion of protected personal information. So would that be a sufficient basis to exclude individuals in Zoom calls if the individual doesn't have an exclusive area for a Zoom call? Well, we've fielded questions already about what do you do when somebody has, they're sharing a home office with a partner, a spouse, an other, and they're using your, confidential trade secrets. So these are real issues. I think that, are there ways, once again, flexibility and accommodation? Can you make in this situation, can you have the person be on a telephone so they don't have to be, they can just call in as opposed to participate that way? And if not, can you, what do you, what do you do? Do you have somebody sign a piece of paper saying I'm protecting trade secrets. Don't have anybody else in the room. I have a private place to work. If those are the concerns, then, consent, flexibility, and can you accommodate? And can you work through possibilities to ultimately decide whether or not you can exclude the person from a Zoom call? But I think that if you get challenged down the road, it's that what did you do to try to make it work that's going to be really important. But I think ultimately, if you can't, you can't, and then there's no other way to accommodate that, then you might have to take that hard line. We got one other question. It was about, I think I've lost it already here, on contact tracing. What's the requirement for contact tracing in California, or is there one?
Right, as part of a go back to work place plan. Now that's certainly something that OSHA has indicated, and Cal OSHA follows, that would be part of a plan or part of your safety protocols, let's say. What's a little less clear is if you don't have or you don't do it, what happens exactly? Have you violated? I mean, that's the guidance. And so I would say, you certainly should be planning on that. There's also local ordinances that require
a number of ordinances.
Yeah, and it really does, it really does become important for folks to be mindful of the county or the city that they're in, because what we have seen is just a complete increase. Like, for example, Santa Clara County has, and I think that was one of the other questions, has a requirement that you do report anyone who has tested positive for COVID-19. LA's requirement is if there's a cluster of 3 or more. So there's a lot of variations on the theme as far as reporting and then notice. One thing that is clear, that the guidance we have from both the DFEH and the EEOC with respect to contact tracing, is that as part of contact tracing, you're supposed to maintain the confidentiality of the person who supposedly has COVID-19. And in small workplaces, that may be difficult to do. But the bottom line is that you're not supposed to disclose that Jane is the one who has it. Other individuals could probably put 2 and 2 together, but that's okay. You let them put 2 and 2 together and determine that it's Jane. Employers are not supposed to disclose that as part of contact tracing.
So we've got one other question, and I just want to, we've put together a FAQs for California employers, because these, we try to keep them as updated as possible. There's a link on Cozen's website, but if you'd like a copy, let us know. And Walter, before you do that, talking about contact tracing. I don't know if anybody saw the California Department of Public Health, just in case you think you're an employer, but now think of yourself as a host for your holiday party for Thanksgiving or the holidays in December, that California Department of public health has mandatory requirements for all gatherings that cover not only the size of the gathering, how many, do you have to have them outside, you can't have, communal food, but you also, if you're the host, that you should collect the names of all attendees and contact information for everybody who is at your gathering in the event that you do need to trace them later. So we are all becoming contact tracers in our own way. And then one last on, can an employer require employees to observe social distancing rules at home as a requirement for returning to the office?
I mean, that's an interesting question. Yeah, I don't know that EOC, well, I know the EOC and DFEH have not addressed that specifically. I guess the question, I mean, certainly you can ask employees if they have been abiding by, social distance and mask wearing protocols, et cetera. I suppose you could use that as a basis for not allowing them to come into the workplace if you think that then poses a potential direct threat. But the issue there is because there is information you can get that would be more direct, including symptoms and potentially COVID-19 testing. Although you should know that the CDC has shifted away from testing and is more of a symptoms-based focus right now. At least that's what they think. So I would imagine you can ask those questions. The real issue is what would you do if somebody says, no, I'm not, I refuse to wear a mask, or, I'm not socially distancing from my young children, for example. You can ask and then make a determination whether you think that it's a direct threat that's being posed to the workplace. And the guidance we get from OSHA and Cal OSHA is that anytime you're making this assessment, you need to make the assessment on an individualized basis. I would just be concerned that if you're going to take any negative adverse action, that there may be more directly related information you could get that tells you whether there really is a direct threat or not. And that's going to be more of the symptoms-based analysis that the CDC wants us to do. I don't know, Michele, any?
No, I think I'm the same way. There's a balancing between what an employer obviously can't monitor in employees' private lives, off-duty conduct, but the EOC, OSHA, DFEH have allowed employers more leeway because of COVID-19 to ask for specific information. So I agree, you get the same information by stating this is what's required when you're in our workplace, but you can ask people, have they been in the past? Have they been associated with people, anybody they know that, that might have tested positive for COVID-19? And you can't, being out in public, there, obviously I don't know if anybody's enforcing them yet, but you're supposed to be wearing masks, etc. But you don't have to do that in your own home with your familiar pod. So I agree with Walter that you could get the same information, you get more direct information by asking specific questions and reminding people when they're in the workplace. And also, this is what, the state or the local area that you're in requires when you're outside of the workplace. So I think so that balancing. And then one last one, and Walter, you want to field something on workers' comp?
Sure. It looks like we're getting more questions too.
Given the 9/17 order by the governor, do employers need to update their workers' compensation postings at the job site? I don't know if they have to. I got to tell you, I'm not sure. I haven't seen any new postings yet.
Yeah, I don't know about the postings. I mean, there are new reporting requirements now that we have, and the reporting requirements are actually to the workers' compensation carrier.
Yeah.
So
I'm not sure about posting though. We can take a look at the.
Yeah, posting. I don't know about posting. I'm not aware the posting was one of the obligations. I
think that between now and January 1, Walter touched on the changes to CFRA. There's going to be new postings that are going to be required, and unfortunately, many people are going to have to redo handbooks this year, and the CFRA is a big issue. And we didn't touch on it, which I think we probably should have, although most people are aware of it. we still have a sexual harassment training that's due at the end of this year. So don't forget that in the, in the pandemic that we've all been dealing with. So I think that's it. With that, let's all wander outside to the bar and the great hors d'oeuvres that the ACC has set up. But thank you, everybody, for attending.